Hi there. I'm Dr. Suzanne Bechtel, a passionate legal educator dedicated to making legal studies clear, practical, and even a little inspiring. On this channel, you'll find a growing collection of videos designed to help you prepare for the Certified Paralegal exam. It covers key topics, breaking down complex concepts, and offering study tips that actually stick. If you're looking for a deeper dive, check out my Teachable School, where I offer structured courses, interactive tools, and exclusive resources to support your journey towards certification. Watch this video to the end and you'll find a coupon code for a discount. Don't forget to subscribe and explore the playlists. Your success on the NALA-CP exam starts here. Now, before we move on to the lecture, there are two important disclaimers. First of all, this is not considered legal advice. Everything shared here is designed to support your learning journey. Also, I am not a lawyer. This course is designed to help you understand the concepts of the exam. Thank you.
Hello, Dr. Suzanne Bechtel here, and this is another lecture on contracts. And this lecture covers the key aspects of contractual intent. We'll be focusing on mutual assent, fraud, misrepresentation, duress, adhesion contracts, and mistakes that affect contract validity. So we'll explore these points that I've already mentioned, mutual assent. We're going to analyze fraud and misrepresentation, compare the two, and discuss duress and adhesion contracts. Also examine the role of mistake and contractual intent. So this is the last element contract that's required, and we talked about the others. We talked about offer, acceptance, consideration, like the need for legality and capacity of the parties to contract. And the last thing we need to discuss here is intent. And we'll see there has to be an intent by both parties to enter into a contract in order for the contract to be valid. So essentially what we mean is that we talk about this concept called mutual assent. It means meeting of the minds. That's what the parties must have when they discuss or create the contract, and they actually intend to contract, and they actually understood the terms and freely and voluntarily agree to the terms, and that they're actually talking about the same thing. You ever had a conversation with someone where you're discussing something and at some point you realize you're not talking about the same thing, and you're talking about one thing and they're talking about something else? If that were the case and you were discussing a contract, that would not give rise to a contract. So we need to have a meeting of the minds. We need to make sure that the parties are freely, voluntarily agreeing to the terms. So what areas of concerns do we have here? There's basically three. We're worried about fraud, we're worried about duress, and we're worried about mistake. Let's turn to mistake and let's discuss the different kinds there. Let's begin with fraud. First of all, fraud is essentially lying, and lying in order to get someone to do something. And you hear about them in the news. There are criminal aspects of fraud. Sometimes people making a false statement to a government agency or bank, that would be fraud. Or coercing someone, lying to someone in a financial capacity to get them to invest money with you in some sort of Ponzi scheme. With contracts, when we talk about fraud, we're talking about fraud in the inducement of the contract. And that is some sort of dishonesty or lying in order to induce the person to enter into the contract. So we would not have a contract if that's the case. There are 5 elements here that we have to have them all. So the first element is a misrepresentation. That means that one of the people or parties to the contract is misrepresenting or lying. The misrepresentation is about a material fact or facts, and a material fact is defined as something that would be important to know or that the other person relies on. Number 3, the third element, is that misrepresentation of a material fact is made with the intent intent being the key word. You're trying to deceive, and that the party intends to deceive the other party, and that the other party relies on that misrepresentation to their detriment, meaning they enter into this contract relying on this statement, and it's harm to them in some way. So keep in mind that all these elements have to be present to have fraud. So if, for example, the misrepresentation isn't about a material fact, it's some little itty bitty fact that doesn't really make a difference in terms of this contract, that's not going to count as fraud. And when you have fraud and inducement, and you've met these elements, essentially, then that party, the innocent party, can choose to void the contract. So we would say this contract's voidable, meaning the innocent party can avoid it like a minor would. If the minor turned 18, they can avoid the contract after they turn the age of majority. Because we talked about capacity, a type of void based on capacity. And a contract, or someone who was drunk in the time they entered into it, but the non-innocent party could not void the contract, so they have to fulfill it, assuming the other party wants to go through with it. But this would be a defense to a breach of contract case, and it's that the person engaged in fraud, and you have to prove all these elements. The second concern we have is called misrepresentation, and it's essentially fraud without the intent to deceive. You have one party here that's not setting out or isn't on purpose deceiving or trying to deceive the other party, but they still gave false information. So the result legally is going to be the same. It's going to be voidable by the innocent party. We're missing that intent because we're missing because of that intent to deceive. So this would be a misrepresentation. And a great example of that would go to a jewelry store and you want to buy a diamond ring, and you ask the clerk to show you some diamond rings, and they show you, let's say, for example, the clerk pulls out a ring, and the clerk believes it's a diamond ring, shows it to you and says, here's a diamond ring. You buy it, you pay for it, and later on you have it appraised and you realize it's a cubic zirconia. It's not real. Well, the results are the same. You still pay for what you thought was a diamond ring, and you've got a big cubic zirconia. So it would be voidable. You could give it back and not have to pay for it, but unless that same using that same example, turning it into a situation with fraud, the diamond ring, for example, if you have that same scenario with the clerk, but the clerk knows they're selling you a cubic zirconia, but they want to make that sale, so they're telling you that it's a diamond in there, and that is an intent to deceive. Certainly would be a material fact that this is a diamond or that it's not, and saying it's a diamond ring, actually it's not, it's a cubic zirconia. So with fraud or misrepresentation, it's going to be the same end result. It's going to be voidable by the innocent party, and the difference between the two is simply the intent. The intent to deceive, that is. And then the last thing we have is be concerned about is duress. If you've studied probate, estate planning law, you may have studied about how one party might unduly influence another party to change their will or that sort of thing. And the same concept we're talking about here, but applies to contracts. It's where you use one party uses force or coercion over the other party to get them to enter into the contract. So there are different types of physical duress. Duress could be physical duress. The typical holding of a gun to your head to make you sign the contract. If it's just the two people in the room, the contract is going to look fine. If you look at it later, it's not going to look like there's any problem, but if we find out it was signed under physical duress, that's going to be a problem. That's not going to be a good contract. It's going to be voidable. So the same thing with economic duress, and that means financial duress. It means you're being forced or signing a contract under the threat of some sort of economic harm, like saying this, or like saying do this or you'll lose your job, sign this or you'll lose your job, or sign this, or I'll take all your money, or something like that. it's mental duress. It would have to do with some sort of mental abuse or mental threats or something like that. So those are 3 types of duress. Another concept of duress is adhesion contracts. If you look at the word adhesion, this is one where party essentially gets stuck with the contract. One party has all the power. The other has no power, and they really can't do anything but take it or leave it. That's the situation with an adhesion contract. So it's not really duress per se, but there's really no bargaining power. And this may be another problematic contract. So another area that we talked about with respect to duress is something called an adhesion contract. I just covered that, but I'm going to provide an example in an upcoming slide. Sorry about the duplication. So what elements are required to establish fraud? What is material misrepresentation and intent to deceive? And what are the legal consequences and voidability of contracts due to fraud? All right, so let's take fraud. First of all, fraud is essentially lying, and lying in order to get someone to do something. And you hear about fraud in the news, as I pointed out earlier. It means some sort of dishonesty or lying, and there are 5 elements, so we have to prove them all. The first element is a misrepresentation, meaning that one of the people or parties to the contract is misrepresenting or lying. The misrepresentation is about a material fact or facts, and a material fact is defined as something that would be important to know or that the other person relies on. The third element here is that this misrepresentation of a material fact is made with the intent of, intent being the key word. You're trying to deceive, and the party intends to deceive the other party, and that other party relies on the misrepresentation to their detriment, meaning they enter into this contract relying on this statement, and it harms them in some way. So keep in mind that all these elements have to be present to have fraud. So, for example, the misrepresentation isn't about a material fact. It's some little itty-bitty fact that doesn't make a difference. That's not going to count as fraud. All right, then we have the voiding for capacity and that sort of thing that comes up in this conversation as well. The second concern we have is called misrepresentation, and it's essentially fraud without intent to deceive. You have one party here, they aren't set out to do that for the purpose of deceiving, but they still give false information. So the result legally is going to be the same. It's going to be voidable by the innocent party, but we're missing that intent to deceive. So this would be a misrepresentation. And we can go back to the jewelry store situation, that the intent to deceive. Sorry about the dog. Again, sorry about that. Anyway, there's intent to sell you the cubic zirconia and pretend it's a real diamond, or it was unintentional. Grabbed it from the wrong case, or didn't realize, wasn't trained, wasn't aware. But the representation has to be material, and that's what we really want to get to. And again, this is all part of the meeting of the minds and aspects of the validity of a contract. So what are the legal consequences and with regard to contracts that are made under fraud? The contract under fraud is voidable by the injured party, and the injured party may seek rescission and damages. And we'll get to that when we get to remedies, including punitive damages in some case. Courts treat fraud as a serious intentional wrong. And there's simple examples out there. A seller rolls back a car's odometer, tells the buyer it has very low mileage. Misrepresentation, we have a voidable contract. The remedy is usually rescission and not damages. No punitive damages will be available because there's no intent to deceive. And the seller, one example is a seller tells a buyer the roof is only 5 years old. This would be a seller of a home. The roof is only 5 years old because that's what the previous owner said, when in fact it's 15. Next, we're going to distinguish between fraud and misrepresentation and provide more examples illustrating misrepresentation in contracts and voidability of contracts due to misrepresentation. Remember that fraud is an intentional misrepresentation and occurs when a person knowingly makes a false statement with the intent to deceive the other party. This contract is voidable. Misrepresentation occurs when a person makes a false statement without intent to deceive, and maybe an innocent mistake or a negligent one. They should have known better. And the contract is generally voidable. So fraud is a lie told on purpose. Misrepresentation is a false statement made by mistake or carelessness. Next, we're going into duress and adhesion contracts with a little bit more specificity. There are different types of duress: physical, economic, and mental. There are legal implications of contracts signed under duress. We're going to go through those. And there are adhesion contracts where we have a lack of bargaining power. A contract signed under duress is one where a party's free will is overridden by unlawful pressure, threats, or coercion. Because genuine consent is missing, the law treats these agreements very differently from ordinary contracts. The legal effect is the contract is voidable. A contract signed under duress is not automatically void. It is voidable at the option of the victim. What this means is that the victim may rescind, which means to cancel the contract, or they may affirm it once the duress has ended. The wrongdoer cannot enforce the contract against the victim, and courts treat duress as destroying the voluntariness required for valid assent. There are remedies available when duress is proven, and a party can seek rescission where the contract is undone, both parties restored to their pre-contract positions, restitution where any benefits transferred under the coerced contract must be returned, or damages, or all of the above. In some cases, especially involving economic duress or threats, courts may award damages for losses caused by the coercion. Next, adhesion contracts. Again, we'll talk about it, but this one I have an example. So we know already their contracts require mutual intent and understanding, and there are different duress types, but adhesion contracts give one party all power, leaving the other with no bargaining power, which risks an unfair contract. For example, Jordan is a 19-year-old college student. He signs up for a new cell phone plan at a national wireless carrier. When Jordan arrives at the store, the sales associate hands over a pre-printed 18-page service agreement on a tablet. And the associate explains, "This is our standard contract. Everyone signs the same one. We can't change any of the terms, but you'll need to accept it to receive your service and have it activated." So Jordan scrolls through it and notices a few things like a mandatory arbitration clause, a limitation of liability provision, a unilateral right for the company to change prices with 30 days notice, and the list goes on. And Jordan asks whether any of the terms can be modified, and the associate replies with no. Take it or leave it. If you want service, you have to accept the whole agreement. So Jordan, needing a phone for school and work, signs the contract. So this is a classic structure of an adhesion contract, where standardized terms and unequal bargaining power, and there's no real negotiation. Next, we're going to look to mistake. We'll look to the definition and types of mistake that include mutual and unilateral. We'll also check out some examples of mutual mistake and contract avoidance. We'll also look to unilateral mistake and enforceability of contracts. A mistake in contract law is a belief that is not in accord with the facts at the time the contract is formed. It's not lining up. Mistakes matter because they can undermine true assent, which is essential for a valid contract. A mutual mistake occurs when both parties share the same incorrect belief about a basic assumption on which the contract is made. The mistake must be shared by both parties about a material fact, which is something essential to the agreement. It needs to be present at the time of contracting. And there are two major types, mutual mistake and unilateral mistake. A contract based on a mutual mistake is generally voidable by the adversely affected party if the mistake relates to a basic assumption, it has a material effect on the agreed exchange, and the party seeking relief did not assume the risk of the mistake. The classic example, both buyer and seller believe that a painting is an original. After the sale, they discover it's a reproduction. A unilateral mistake occurs when only one party is mistaken about the material fact at the time of contracting. And the legal effect of a unilateral mistake is a contract based on unilateral is usually enforceable unless, and there are three reasons: the non-mistaken party knew or should have known of the mistake, the mistake makes enforcement unconscionable, and the mistaken party did not assume the risk of mistake. And courts are more cautious here because allowing rescission too would easily undermine contract stability. So your classic example is a contractor accidentally typing 8,500 instead of 18,500 in a bid. If the other party knew or should have known it was an obvious error, the contractor may rescind. So the enforceability of a contract with a unilateral mistake involved. Again, a unilateral mistake happens when only one party is mistaken about a material fact at the time the contract is formed. The key teaching point for you is to realize a contract with a unilateral mistake is usually enforceable. And courts don't let parties escape contracts simply because they made a one-sided error. But we need to look to exceptions, as we always do in the law. Courts will enforce contracts even when one party made a mistake because contract law values certainty and stability. Parties are expected to read carefully, double check, and bear responsibility for their own errors. And allowing easy rescission would undermine commercial reliability. So the default rule here is that a unilateral mistake does not, as a matter of law, void a contract. But there are exceptions. Exception 1, the other party knew or should have known of the mistake. If the non-mistaken party knew, suspected, or should have known that the other party made an obvious error, the contract may be voidable, such as when I gave you the example earlier, the 8,500 instead of 1,800 on the bid. Exception 2 is that the mistake makes enforcement of the contract unconscionable. Even if the other party didn't know, a court may refuse to enforce the contract if the mistake is extreme, if the result would be shockingly unfair, and the mistaken party did not assume the risk. And this is often applied in the cases of clerical or mathematical errors, as they can come up with some pretty disproportionate outcomes when you do the math. Courts do avoid enforcing these gotcha contracts. And then there's a third exception. The mistaken party did not assume the risk. A party assumes the risk when they sign as is. We talked about that in offer and acceptance. They know they have limited information, but proceed anyway. The contract allocates the risk to them, and if the mistaken party assumed the risk, the contract remains enforceable, even if the mistake is serious. So everyone needs to, when they're entering into a contract, manage your risk factors. Allocate the risks appropriately based on the information you have. So it's pretty simple to realize that unilateral mistake rarely invalidates a contract unless the other party knew about the mistake or enforcing the deal would be unconscionable. And unilateral mistake is not a free pass to escape a bad bargain. So in conclusion, we talked about mutual assent and the essential need for valid contractual intent. And when there is a defect, there may be opportunities to avoid the contract through asserting a right, and the harmed party can assert that right. And then, so understanding key legal aspects, these are going to help you ensure the fair and enforceability of contracts. So this is the last of the lectures that in contracts that really sum up what is a contract, what is a valid contract, what is an enforceable contract, and sprinkling in unenforceable topics. So realize as we navigate the coming up lectures, we'll be peeling this apart, all of these points apart, here and there to provide a better structure to your knowledge bank. So thank you very much.
I hope you got some good information from this video lecture. Don't forget that I have a Teachable school account. Here is the address for that, mayananda-s-school.teachable.com. The name of my school is Mayananda. And also there's a coupon here for you to save some money. And finally, good luck on the exam. And don't forget to like, share, and subscribe.